I'm looking at a provisional patent application that was prepared by a former Biodesign team, and I'm going to share with you some of my observations as I go through this patent application. First, I like to keep in mind the goal of the patent application because that governs how I judge the content. The goal is to provide written description support for claims down the road. So any words in the patent application that do not appear to provide support for claim strategies at a later time, to me, are of little value. So if you have limited time in writing a provisional patent application, please spend most of your time describing what your invention is and how to make it and how to use it, and very little time talking about the prior art or the broader context. This patent application does a good job of focusing in immediately on the subject matter of the invention. It articulates on the first page that the present invention is related to closure of vascular access openings created during percutaneous vascular procedures. That's a great opening sentence, and every patent application should have a context driver of that sort. However, the next section I would urge an author to do somewhat differently. For example, the first paragraph under the prior art, although interesting, has no content in it that supports claims down the road. The context of the invention has already been established as vascular closure devices, so while that language is not harmful, it doesn't help us support additional claims down the road. The second paragraph has one sentence which I find valuable, and that is, our present invention proposes to use a balloon catheter passed along a guide wire to dilate an arteriotomy after initial arterial access. That's content that's describing the invention. The rest of this paragraph doesn't help support additional claims. It does try to distinguish the prior art, and there are different schools of thought on the value of distinguishing the prior art. Legally, that has no value. There's no statutory purpose today in distinguishing prior art in the patent application. Many years ago, the background of the invention was the vehicle by which a patent applicant satisfied their duty of disclosure of prior art to the patent office. However, today we have an information disclosure statement filing process that accomplishes that goal. So the background of the invention section is largely legally irrelevant in today's world. There are a couple things in this application that are beyond neutral but potentially harmful. For example, in the second paragraph, the author articulates issues concerning freedom to operate and whether or not a patent creates an issue with respect to freedom to operate. I would urge you to never, ever make a statement relating to risk of infringement or freedom to operate or concern of any issue concerning somebody else's patent. There's absolutely no upside to that. And when you're on the witness stand years later defending why you wrote that because they're asserting willful infringement, it can be very uncomfortable. So no upside, potential big downside. Don't talk about other people's patents from a risk perspective. The same is true of the remaining paragraphs of the background of the invention section. They're largely devoted to distinguishing prior art, which is not necessary. So in my view, in this patent application, probably an unnecessarily large amount of effort went into the background of the invention relative to the effort that went into the detailed description of the invention.